appointments in higher judiciary, and was also a part of the 9-judge bench in Justice K.S. Puttaswamy versus Union of India case, which declared privacy as a fundamental right. Honorable Lordship retired on June 22nd, 2018. Today, JSS Law College and the NEETI Forum feel honored to have His Lordship with us. Thank you.
Thank you, Pratyush. We learned so much from the brief introduction. I can only imagine how much more is left to learn today. May I now request Honorable Mr. Justice Jasti Chelameshwar to grace the occasion by his beneficial words.
Good morning to all of you. Am I audible? Okay. Now, before I say anything about this concept of the rule of law, I would like to hear from one of the students as to what, according to them, is this concept of rule of law. Any one of the students can answer. Of course, not faculty members, only students. Anybody. So that I can make an assessment where to start. Is anybody willing to speak out?
Good morning, sir.
Yeah, who is this? Who is this? I'm not able to.
Sir, this is Vedashri.
Where are you, young lady? Do I see you here? Can you just lift your hand? Oh, okay, good. Yeah.
Sir, rule of law is everybody is equal in the eye of law, and law is above everyone. So it is the rule by the law and not rule by the men. This theory was proposed by Sir Edward Coke, and later it was expanded by A.V. Dicey.
Fair enough. Now, that Vedashri, we are close to the concept. Though there are embellishments made, but obviously you would have picked up these ideas somewhere, no problem. That basically the rule of law, equality before law is another concept altogether. Maybe it's an aspect of the rule of law, but not necessarily part of the definition of the concept. Now, what essentially rule of law, according to me, is in a simple say, okay, volumes and volume libraries have been written about this concept. I can't obviously go into all this thing. As you rightly said, the last sentence of the statement, as against the rule by men. In other words, the modern societies of time, the mankind developed this concept of rule of law in contradistinction to the earlier ages, Middle Ages and even earlier ages, where societies were ruled or governed by individuals, by kings. Well, you know, as a student, you would have studied a bit of history. Now, these people, these kings or queens in some places, they were there by an accident of birth. There were certain rules of succession. And then there were a lot of attributes. People believed that these people, by the accident of their birth, have some divine investiture in them of the authority to rule over their subjects. And second thing is, for a long time it was believed that the king or monarch, or whatever name you call, whatever ruler carried in a given society, is an absolute monarch, and there are no limits on his authority to deal with his subjects. There are no limits of his expression of either pleasure or pain. The king was pleased. Even of course, when I say king, there are students of law, but the guys don't get angry with me. King always included the queen whenever there was a queen, but not many queens were there in history. There's a different story. But kings and queens, they were equally autocratic. But they had the authority to distribute the state property at will. If the king is pleased with somebody, the king or queen could make somebody a zagirdar overnight or a fief holder overnight, this kind of. Or if the ruler, the king or queen, is not satisfied or pleased with somebody, would have simply ordered the beheading of the person whom the ruler is not pleased with. Well, of course, there are more horrible cases. I don't know how many of you are aware. But a lot of you would have heard at least the name of Muhammad bin Tughlaq. Well, of course, he is known for various antics of his. In some aspects, some of his we're not going into it. But that man, one of his most favorite punishments. Can you just make a wild guess what would have been his most favorite punishment? Can anybody answer? If anybody has ever touched this subject anywhere? Okay, I'll not waste your time. The most favorite punishment of this man, of course, not alone this man, but a lot of other fellows emulated him later. They found it very, very exciting. Flaying a man alive, man or woman, mostly it was men, of course. Flaying a person alive, you understand what I say? They used to peel off the skin of a person while he's alive and allowed to die. It would be a torturous death, if we can only imagine. The very hearing about it itself makes us, revolt with. This is what is meant by rule of men. And of course, this Muhammad bin Tughlaq was not alone ruler who imposed this punishment, but a lot of fellows in those days, that period, imposed this kind of punishment. There are people who impose punishments like pouring molten lead into the ears of somebody who is not pleased. So therefore, from there, the mankind progress. And they look at this kind of barbarous things are not to be done. Somebody is found. First of all, the person who is to be punished must be punished on some rational grounds, on a rational process. Second thing, if the person is to be punished, the punishment must be a little more forceful. But this is a different concept of refinement, and is a different concept. Apart from now, you can still make a law. In some countries, it's still made. For thieving, the punishment is chopping off the hands of the convict. So some countries follow this kind of a law. But then there you can't say it is not, there's lack of rule of law. The law still exists. It is not chosen arbitrarily in the case of one individual or somebody with whom the ruler is not pleased. Anybody who is found guilty of thieving, the punishment is the same. So therefore, there is uniformity, equality before law, chopping. But then whether it is also a liberal way of dealing with this is a different question. Now, but equality certainly exists in these matters. I'm sorry. I'm sorry, excuse me. Little allergy problem. Now, slowly from that phase in the history of mankind, humanity developed the concept of a democratic rule, a liberal democratic rule, constitutional governance, and rule of law. That means first, make a law. People must know citizens of the state. The law is not applicable not only to the citizens of the state, even a foreigner residing in India is subject to the law of this country, so long as he is there available on the soil of this country. So the word subject take in both citizens as well as non-citizens who are amenable to the process of law. Now, question is, the subject is required to know in theory. Every individual would know the whole body of law, not is a different story. But if he makes an effort, he'll be able to access the information that there is so-and-so law. In India, there is a law by which murdering another human being is an offense for which penalty could be, death penalty could be, not life, in the alternative. So this is already available there, published, well published, and well known. Somebody says, I don't know, I have not heard of it, that's his problem. But then the requirement is not that everybody should know it, but it's available to everybody who makes a little reasonable effort to find out. Then it is the rule exists. Then subsequently, if somebody is found to have violated some provision of law, not necessarily killing somebody, where every law creates rights and obligations, as you know, stewards of law. So if somebody is found to have violated some obligation imposed by some law, then there would be consequences. The consequences in a given case, depending upon the nature of the prescription of the law and the prescriptions made by the law, what would be the consequences or civil consequences, so criminal consequences would depend. Now, with respect to the fact whether the consequences are civil or criminal, law exists and the consequences of the violation of the law are also available for the subjects to know and access them. Broadly speaking, this is the concept of rule of law. Now, whether the rule is also required to be equal in its application, there is a constitutional requirement that the law shall be, nobody shall be denied the protection of the equality of laws. There are further refinements on the concept of rule of law. There are constitutional rights and developed by mankind centuries. Now, making an abstract lecture on the rule of law is not, in my view, going to take you people, the youngsters, anywhere. I never believed in this kind of lecturing. I would prefer to just give a couple of cases which I dealt to demonstrate how this system, or how, to what extent, I noticed from the questions circulated to me, to what extent the rule of law is being implemented in this country. At the outset, I'll tell you, some degree of rule of law exists in this country. Otherwise, you and I will not be able to sit like this peacefully and hold seminars or lectures like this. We are able to sit at home without being disturbed by the society, rest of the society, or some unruly neighbor, or some lawless element. Lawless element do exist, always existed in human history, right from the beginning. They continue to exist. There never was a period in the human history where lawless element did not exist. Point is, the broad features of the social order, we take them into all done. We still live in a relatively peaceful society. In the sense, we can go out into the streets and generally we can come back safely without being robbed or without being molested or without being beaten up. Generally. Occasionally, incidents do happen. How many of them happen? All law is meant for handling those situations. We live in a society broadly governed by the principle of the rule of law in this country. Whether the situation is perfect or not is a different matter. At a philosophical level, I can tell you, because I'm certainly, perhaps, I don't know whether any one of your teachers is older than me, but I'm sure, obviously all the students are younger than me, much younger than me. I can tell you as an old man, it's not perfect. Then why is it not perfect, and why I say it is not perfect, I'll tell you. And what is your role as budding lawyers or law students? What is your role in trying to improve the system? So I'll talk to you today. For that, I'll just give you a couple of cases which I did to demonstrate. As I told you, I'm sure all of you would have noticed that maybe a year back, there was an incident in Hyderabad system. A young girl, while returning from work late in the night, was unfortunately raped, and she was also killed thereafter. The body was burnt. sure most of you have known this incident. It appeared in the newspapers very prominently. A lot of information came on those days. A couple of days, I'm sure this kind of an incident must be happening all over the world, all over the country. We know of cases in the Western Hemisphere of serial killers, Jack the Ripper, and kind of things. These kind of things happen, of course. There are insane people in the world. There are a lot of elements in the world. It's very repulsive that such things happen. An innocent, helpless girl being abducted by a gang of 3 or 4 people and raped and being killed is something which is obnoxious. Nobody can approve it. Nobody can. But question is this: how to deal with such offenders? The question. When we talk about rule of law, what is the norm? Suppose if an individual is accused of killing somebody, what do we do? What does the law do in the existing system? The police register a crime, collect evidence, because ultimately it is in a court of law, it is evidence that matters. Police, what the police say is not the final word. The court must be satisfied that the police are producing reliable evidence that innocent people are not being targeted by the state or its agencies. Therefore, the system trial was evolved over a period of centuries by an independent body. That independent body is the judiciary. Now, the accused is brought before the judiciary. The evidence to say that this accused has committed so and so offense is produced before the judiciary. Judiciary examines the evidence, considers whether the evidence is trustworthy, considers whether the evidence was procured in accordance with the prescription. See, as you know, as students of law, by now you must have, I don't know, at least some of you must have completed the Evidence Act. And you know, statements made to a police officer are not admissible in a court of law. The reason is some 175 years, 60 years, whenever the Evidence Act was drafted, Prisoner Act. Even by then, the lawmakers, the members of the Parliament, British Parliament, realized as a social condition that the law enforcing agencies like police are capable of extracting, and these things had historical background, are capable of extracting confessions at gunpoint. You know, the person taken to the lockup can be beaten up and made to say whatever the police want to say. So to avoid, if people are to be convicted on the basis of such statements extracted from the witnesses, nobody is safe. Anybody can accuse me tomorrow that I am responsible for murdering Mahatma Gandhi. And then half a dozen people will be beaten up in the lockup and they'll come and depose before the court saying, yes, we saw Chelameshwar killing Mahatma Gandhi. Then the question is, whether I was born on the date of Mahatma Gandhi's death or not is a question which the court will have to ask. So that is the test to decide whether the witness are speaking the truth or not. This is how the evaluation of the truthfulness or otherwise of the witness is made. Now, if this is the normal process, some 4 boys were they were suspected to be the accused in the particular case of raping and killing the girl. Maybe there is truth there, but this is truth will have to be ascertained in accordance with the procedure established by the talking about rule of law. That truth will have to be established in accordance with the procedure established by law. Unfortunately, what happened is a couple of days later, those 4 boys were shot to death by the police. Of course, the information put out in public domain is that while being transported from the court to the prison for remand, these people try to escape. All these kind of stories are always there. Point is, the 4 boys were killed. Maybe they were guilty, maybe they were not guilty. Maybe one of them is not guilty, or maybe 2 of them were. You don't know really, unless somebody makes an impartial investigation into it. And see, the police officers involved in that particular case may be very honest people. I don't know. But even then, they have no authority to kill. The rule of law is that if a death penalty is to be imposed, it is to be imposed by the court, the sessions court. And for information, since you are youngsters, I don't know how many of you completed your study of CRPC and IPC. The penalty is to be imposed. The requirement is on law is of the CRPC. Only the Sessions Court can give the penalty, and that penalty is subject to the confirmation by a High Court. On the announcement of the judgment of the Sessions Court, a person can be executed. It will have to be confirmed by the High Court. There is a reference to the High Court. And trial takes place. So there is a process, elaborate process. This process is called the rule of law. If this process is violated, is not complied with or not followed, then there is a breach of the rule of law. Now, point is, the ghastliness of the crime makes some people to believe that the departure from the rule of law is just right. In fact, I don't know, you must have noticed after this incident, there were huge processions in parts of Hyderabad city, congratulating the police and showering flowers on those officers who were involved in this shooting of the student. Now, it's all fine. Maybe a very rough and ready justice was done in that case. I don't know. I don't have that omniscience to know whether they caught the right people or wrong people. I'm only trying to decide cases on the basis of evidence. But point is, it's a very dangerous thing. Tomorrow, if somebody powerful is not happy with you or me or any one of you, we can simply be accused of a crime and of a very dirty crime, and afterwards anything can happen, including this kind of shoot to death. This is not true. Now, fortunately, such incidents are stray incidents in this country. This is technical. Though there are considerable number, taking the total population of this country of 1.3 billion, how many of such incidents happen? The numbers are low. We still say we live in a country where we are bound by the rule of law. But only these examples are only shown to explain what exactly is the rule of law and how it is breached. I'll give you a less distasteful example. One of the last judgments which I read sitting in the Supreme Court, it's reported in 2018, 7 Supreme Court cases, page 743. It's a case where some 17 people were accused of causing or accused of a particular transaction in which 3 people died. This happened in the state of Gujarat, some small town, some village, Nana Ankadia, some small village. And it happened sometime in 1992. It was some local problem, factions and whatever. That night around 10 o'clock, such an incident took place, leaving 3 dead bodies, quite a few injured, 17 accused, and 3 people died and a few more people are injured because there were injured witnesses who spoke to the incident. Injured. Obviously, there was a group clash, 2 groups clashed there, and unfortunately for us, nothing, it has no religious connotations, it's a local problem. Nothing. Because nowadays, when you say 2 groups clash, immediately doubts arise whether it has nothing to do with religion. It's purely personal. This gang wars kind of thing. Now, finally, 17 people were accused. And these people were put to trial. I'll tell you what all had happened. I'll tell you in little detail. I'll give you the sketch of the case. Finally, the trial court found 2 of them guilty of murder under section 302 IPC and directed that they suffer imprisonment for life. And 3 other persons were found guilty of lesser offences of 323, 326, 323, 326, and an offence on Arms Act and so on. They were not found guilty of the major offence of 302. They were awarded lesser punishment, 3 years to complete the judgment. It's a reported judgment. Now, why did I choose this case as an illustration today in the context of rule of law? To my mind, I can go record it. So, sitting in the Supreme Court and another learned judge, sharing with the bench, we recorded. Probably everything went wrong with the case. Now, from 1992, it took 26 years for the matter to reach the Supreme Court, various levels, trial court, high court, and Supreme Court. That time frame itself is an aspect of rule of law. I'll talk about it a little later. Now, apart from that, all these 17 people were accused of various offences, starting from 143. One second, I'll just give the list of all these offences on which they were. The trial court stated as follows. There are charges of offences under 302, 307, 324, 147, 148, 149, 120B, Section 25 of Arms Act, and so on and so forth. Now, at least those of you, I'm told that the students of various classes, first year, second year, I don't know how many of you have completed your paper on Indian Penal Code. 148 is an offence of rioting armed with deadly weapons. Okay. Now, when it reads something like this: whoever is guilty of rioting, being armed with a deadly weapon or with anything which used as a weapon of offence is likely to cause death, shall be punished with imprisonment of either description, so and so. So then, whoever is guilty of rioting, what is meant by rioting? What a common man understands about the word rioting is a different matter. I am not about that right. In law, the riot is a distinct offence under Section 146 IPC. Now, what is that 146 IPC? Whenever force or violence is used by an unlawful assembly or by any member thereof in prosecution of the common object of such assembly, every member of such assembly is guilty of the offence of rioting. So, to constitute an offence, certain elements are required to be established in law. First of all, there must be an unlawful assembly. What is an unlawful assembly? It is not some divine expression. It's a defined expression under the Indian Penal Code. Unlawful assembly is defined under Section 144. It has ingredients. It requires minimum 5 people. They must have a certain intention of commitment, so on and so forth. If you studied the Penal Code. Now, therefore, if somebody is to be punished for an offence under 148, then there must be an unlawful assembly. There must be a offence of rioting, that is that they cause violence, and such violence is caused by the use of deadly weapon, then it becomes 148. Now, if the 3 of the accused and the 3 or 4 of the accused in this case are found guilty of an offence under Section 148, without there being any inquiry, without there being a proper charge or a finding, whether there was an unlawful assembly at all. Because as I told you, unlawful assembly is a defined expression. It requires minimum 5 cases. There are 17 people in this. Then that is not only the number which is sufficient to establish an unlawful assembly. The assembly must be with a certain intention. You read the definition of unlawful assembly. Now, these are all elements which are required to be established in law. If all these elements are established, there is an unlawful assembly. That conclusion is arrived at. The next question is whether this unlawful assembly need not commit any crime. The mere intention of committing an unlawful act is sufficient to constitute an unlawful assembly. Afterwards, no offense need be committed. Now, if they also employ violence, such an unlawful assembly employs violence, then it becomes further offense of rioting. And if violence is perpetrated by the use of deadly weapons, it becomes an offense under 148, rioting armed with deadly weapons. So necessarily, if we believe in the rule of law, we must first record a conclusion that there is an unlawful assembly satisfying the various elements of the definition of unlawful assembly. That unlawful assembly committed an act of violence, the second finding. Then that violence was committed through the means of deadly weapons, the third finding, which makes the accused guilty of an offense under 140. Now, if unlawful assembly, as defined under 141, exists without anything further, 5 people gather there with the requisite intention as expressed under 141. Whether they do something further or not, the mere fact that they assemble together is good enough to constitute an offense for which there is a punishment under 143. The punishment is 6 months. They need not do anything. Or 5 people or 6 people gather. They decide to beat up somebody who is passing by. They decide. Well, after deciding it, they may not really execute it. But the very fact that they decided to beat up somebody itself is an offense because it's a prohibited activity in law, beating up somebody. So the assemblies, the offense of unlawful assembly is complete. They are liable for punishment. Then, as I told you, further things. So, unless there is a clear finding, there is an unlawful assembly. Nobody can be punished for an offense under 148. Unfortunately, in this case, there is no such finding. There was no such charge. 143 charge is missing. 143 charges there. I'm saying 143 charges there, but finding is not there. Because I told you 143, the requirement to find somebody guilty of an offense under 143. All the various elements will have to be established. Nothing is there. Straight away they jump to the conclusion 148 offenses committed. That's one thing. And more important is, of the 17, only 5 people were convicted. 12 people were acquitted by the trial court. I'm not to go into this, acquittal is over and it's all over story. It doesn't matter. The point is, if there is an unlawful assembly, if there is a proper finding that there is an unlawful assembly, any person who is a member of the unlawful assembly is constructively liable for an offense. If somebody may be a member of the unlawful assembly, one of the members of the unlawful assembly kills somebody else by shooting, and all the remaining members had the same idea. The person who pulled the trigger may not, only one person can pull the trigger. But other 5 or 6 people who shared the same intention are equally guilty of an offense under 140 of murdering that victim by virtue of the application of Section 149. Therefore, the establishment of the offense of unlawful assembly, an inquiry into the existence of an unlawful assembly, is the most essential in matters like this where a number of people are involved. If these things are not taken care of and the matters are adjudicated, then there is anything but the rule of law. It is some rough and ready justice, the kind of it's slightly a couple of degrees lesser than what happened in Hyderabad. So it happened in the hands of the police, it happened in the case of judiciary in this case. A couple of degrees, only the people are not killed, they were sent to jail. But then still it was not a rule of law. There is a breach of the rule of law. Now, eventually, all this leads us to the conclusion that in a society, civilized society, and a society governed by a constitution. And each member of the legislature, executive, and the judiciary is obliged, is under an oath to uphold the constitution and the laws established, has an obligation to clearly understand and ensure that the law is enforced, that there exists a law, and the law is implemented in the true spirit in which it is made. That is the society where a rule of law prevails. If any one of these elements is missing, there is a failure of the rule of law. Now, as I told you to start with, these examples, of course, these are not the only two examples. I'm sure there will be hundreds and hundreds of examples at any given point of time, or maybe thousands of examples at any point of time. Nonetheless, with all these shortcomings, we still live in a society where some semblance of rule of law is continuing, because in a good number of cases, people are prosecuted and punished for in accordance with the procedure established by law. Examples which I have chosen are those cases where to demonstrate what is the failure of the rule of law. There must be a lot of cases where the law is faithfully implemented. But at the same time, there is I believe, and you youngsters should understand, that the situation is certainly not absolutely happy situation. There is a need to be a little more alert and cautious about it. And I'm sure one question, yes or no answer from any one of you people. There is a book titled Maximum. Anybody from Bombay in this gathering? Can somebody raise the hand? Nobody from Bombay. Okay. Now, there is a book titled Maximum City by an author called Suketu Mehta. Did anybody read it? Now, the point is, in the book he describes, I suppose all of us know, at least by not by direct information, by watching the Hindi movies and things like that. There is an underworld in Bombay, and everybody must become too old and old character. There is a character called Dawood Ibrahim, about whom a lot of stories are available in this country. And a lot of other people, not only a lot of other people. There are people who control the Bombay city, kind of, these kind of stories are available. And what happened, and then Suketu Mehta writes in the book, the knowledge of many Mumbai cars. In Mumbai, a lot of these disputes, people don't go to the police. They go to one of these strongmen. So, look here, I have a problem. I have rented out my apartment. The tenant is refusing to vacate. And if I go to the court to evict the tenant, it takes 20 years, 30 years because trial court, high court, Supreme Court. It may take 30, 40 years. The easier way is go to one of these people. They'll simply get the man evicted within 15 days of the thing, effectively at gunpoint. So therefore, people prefer this than the process made available through the rule of law procedure, going to the rent control and I'm not making this statement to my youngsters responsibility. Long back, when I was a Retd in Andhra Pradesh court, I came across a bunch of cases where the allegation is that in a particular district of Andhra Pradesh, wife and husband quarrel. And the wife goes and lodges a police complaint saying that my husband is trouble. Police immediately call the husband to the police station. And whatever, according to the police, they counsel him. I don't know what kind of counseling goes on in a police lockup. I'm sure you can imagine. are landlord and tenant disputes. The landlord goes to the police station and says, my tenant is troubling me, not paying the rent, is not vacating. Please do something about it. Immediately, the tenant is called to the police station and is counseled. Our brothers quarrel about joint family. I'm talking about cases, concrete cases which were placed before me. I'm not imagining these examples. These are all concrete cases which are listed before. Brothers quarrel about ancestral property partition. So one of the brothers, more imaginative fellows, instead of going to the court. Normal requirement is there is a quarrel about ancestral property and partition. I suppose as students of law by now you must have been taught, and you go to the civil court, file a suit seeking the partition of property, family property. Now, the more resourceful people don't do that. They go to the police station or some local strongman, get it, you know what kind of an adjudicated process goes on. Just imagine, if you don't know it, just imagine. If you can't even imagine it, find out from somebody, which is not a very wholesome affair and which is not a thing to be decided, because anybody can be, any one of us can become a victim of that kind of a process. And more you, not me, not because I was a former judge, but I have a few more years left in my life, but you have a long way to live. So therefore, any one of you can get into this kind of a problem unless this rule of law is maintained in a system. So I think I have taken enough time of yours. Just as an introduction, I'm not saying this to be a very comprehensive or exhaustive lecture on rule of law. Just to give you an idea of what. Now, it could be a very high funda lecture giving quotation from this book that but I thought as an youngsters, you must know the reality more than this rhetoric. So, my dear friends, last word is, since all of you are studying law, then you will enter the world. Some of you will become lawyers, carry on the profession. Some of you might become lawmakers. I don't know, maybe somebody will, one of you will become an MLA and pay. Some of you will possible, or maybe somebody will become a minister sometime later in life. Some of you might become judges, or some of you may simply become administrators entering civil service. Civil service is nothing but enforcement of law. So wherever you are, your knowledge, when which of the knowledge of law which you have here, please remember that you have a duty to understand the law correctly and implement the law sincerely for the benefit of society. So keep this always in mind. I wish all of you all the best. Thank you for the invitation. Thank you.
Thank you, Your Lordship. It was a pleasure to be a member of the NEETI Forum to witness this day. The volunteers are now requested to hand over the questions, please, with Your Lordship's permission. Thank you, sir. The first question being, Your Lordship, would you like to recall or recollect anybody who might have helped you to become who you are now?
Come again.
Would you like to recall or recollect anybody who might have helped you to be who you are now?
There are a lot of people who helped me to become what I am, starting from my parents, my teacher, not necessarily teachers in the local age, teachers who taught me the elementary education in the school, who imparted whatever values which I have today. You may agree with my values, may not agree with my values, those people, from my law teachers, from the seniors in the profession from whom I learned. There are a number of people who were responsible, who helped me to become what I am today. So therefore, giving one name would be, two names would be doing injustice to others. And I'm sure in life, my dear students, I tell you, if you are willing to learn, every human being, not only human being, every being with whom you have you happen to have some interface has something to teach you.
Moving on, Your Lordship. Your Lordship, as we all know, you have held a lot of positions throughout your career. You have been a member of the bar and the bench. What would you like to suggest to those students who are interested in judicial service exams after their graduation?
please go ahead. We need good judicial officers in this country. We need knowledgeable, we need sincere, committed, honest judicial officers. More the better. We need a lot of them. If some of you want to get into judicial service, you are most welcome, and I'll be very happy. But remember always, as I wanted to know, that it is a duty we owe to the society. And the basic rule is speaking truth. What is truth, and a great sense of what is right and what is wrong. Those things are a must. Yes.
Your Lordship, what is the future of virtual courts, keeping the present scenario in mind?
Well, I am not really able to, because technically it has the virtual courts have a great future. To what extent the Indian society, particularly the bar and the Indian bench, would accept it as a permanent feature, I can't hazard a guess right now. Because generally, as I know the bar and the bench, they're more conservative. Any change, the tendency is to resist. And of course, nobody can resist changes forever, because they're compelled by extraneous circumstances. For example, this pandemic, now there is a compulsion to use virtual court system. Now, to make it a permanent affair, maybe a little more compulsion is required, even after the pandemic ceases, to continue with the virtual court system. It's a great guess I have to make. Well, sometime or the other, maybe 30 years, 40 years, I don't know. For a bit of time, it's bound to happen, I believe. That's what I cannot be immediately.
Oh, thank you, Your Lordship. Your Lordship, what persuaded you to take up law after obtaining a degree in BSc in physics?
I was a bad student of physics. Therefore, I went to the law college. That's one reason, really. See, I tell you, I was not really bad student of physics, but I had some problem with mathematics. I'll tell you some interesting thing, personal thing. Do you kids ever get a nightmare? I'm sure everybody must be getting. I don't know if their nightmare varies from person to what is somebody's nightmare. It might not be the same for somebody else's nightmare. I do still get a nightmare occasionally, even in the age of now I'm running. I completed 68 years. The only nightmare I get is this: that I'm sitting in the examination hall to write the mathematics paper, and I'm not able to understand the question, because that's the only nightmare I get even today. I had some mind block about mathematics. Though I got a first class in BSc Physics, mathematics pulled me down. I obtained 59 marks in mathematics. 59 is a very bad mark in mathematics. Normally, that's a paper where you could score 100 out of 100. Why it happened is a different story. This thing. After that, I decided with a weak, foundation in mathematics, study of physics, advanced physics is not going to really be of any great use to me. Then I had to take a call what to do next. Then I chose law because it was in the family. My maternal grandfather was a lawyer. My father was a lawyer, but he didn't practice for many years. For a few years he practiced, he stopped. There are 3-4 lawyers in the family from the other side. So I was naturally attracted to this profession. That's what prompted me to do this.
Moving on to the last question, Your Lordship. What
Yes.
is the most memorable experience throughout your career? Which has been the most memorable experience?
Memorable experience in my... There are quite a few, but you have asked me to mention one. Long back, I handled an election case in Andhra Pradesh. Somebody got elected to the legislative assembly. The election was challenged by the opponent, losing candidate. I applied for the winning candidate. And in the election petition, eventually, I lost the case. My client got a he ceased to be a member of the Legislative Assembly by virtue of the High Court judgment. He's on a technical ground, not that he was a bad man. He had some subsisting small contract. The ground that he had a subsisting contract on a technical ground, he lost the election petition. Now, when the election, then I was pitted against two eminent counsel in that matter. I was young when they argued this matter. I was hardly 9-year-old at the bar when I argued this case, when I conducted this election petition. I was pitted against two senior counsel. One conducted the trial part of the election petition, and the other senior counsel was former Advocate General of Andhra Pradesh, who argued the matter. I was pitted against both of them. Because I lost on a technical ground. I lost the matter. That itself was a memorable experience at the age of professionally 9-year-old. Pitted against two eminent senior counsel. And what makes it more memorable to me is after the judgment was delivered, I lost the case. I was walking out of the court. The election petitioner, the candidate who won the election case, who lost the election but won the election case, standing outside talking to the lawyer, the elderly man, was also a practicing lawyer, incidentally. So first time he accosted me because all those earlier days, the matter went on for 7-8 months. Those days, since I was a lawyer on the opposite side, obviously he never repeated this thing. That day, after the judgment was delivered, he accosted me. He said, was in my mother tongue, he said, Babu, I just want to talk to you. Don't worry, I'm also a lawyer. Don't worry that you lost the case, but you have done exceedingly well. I'm not saying to please you. And he said it. If ever I have another election petition in my life again, I'll engage you next time, he said. I think that was a moment of great professional satisfaction.
Thank you, Your Lordship. JSS Law College Autonomous and the NEETI Forum is grateful to Your Lordship for interacting with the participants and clearing the ambiguity. I now request Ms. Pragna to render the vote of thanks.
Good morning, everyone. My name is Pragna Nagraj, and I take this opportunity to propose the vote of thanks on behalf of the NEETI Forum and JSS Autonomous Law College. Firstly, I express my heartfelt thanks to His Lordship Mr. Justice Jasti Chelameshwar, former judge of the Honorable Supreme Court of India, who, in spite of having a busy schedule, graced the occasion with a thought-provoking lecture. I also express my gratitude towards Professor K.S. Suresh, Chief Executive of JSS Law College, Dr. S. Natraju, Principal of JSS Law College, Mr. Pranam Nair and Ms. Neha Jagdish, Faculty Coordinators of the NEETI Forum, for their guidance and moral support to organize this webinar. I thank Mr. Madhu Kumar and Ms. Prajwala for the technical assistance and all the members of the NEETI Forum for their cooperation and hard work. I also take this opportunity to thank each and every one of you for having been a part of this webinar and making it a successful one.
Thank you, Pragna. Taking your leave for the day, I thank every one of you for being a part of this event and making it a fruitful one. Thank you, Your Lordship.
Thank you.